Criminology Board Exam Reviewer. Criminal Procedure. Definition of terms. Part 1. Criminal Procedure. Criminal procedure treats of the series of processes by which the criminal laws are enforced and by which the state prosecutes persons who violate the penal laws. It regulates the steps by which one who committed a crime is to be punished. Jurisdiction over the subject matter. It refers to the authority of the court to hear and determine a particular criminal case. This simply means jurisdiction over the offense charged. Jurisdiction over the person of the accused. It refers to the authority of the court over the person charged. Criminal action. It is one by which the state prosecutes a person for an act or omission punishable by law. Information. Information is an accusation in writing charging a person with an offense, subscribed by the prosecutor and filed by him with the court. Complaint. Complaint is a sworn written statement charging a person with an offense, subscribed by the offended party, any peace officer, or other public officer charged with the enforcement of the law violated. Amendment of complaint or information. Unamended information refers to the same offense charged in the original information or to an offense which necessarily includes or is necessarily included in the original charge. Hence substantial amendments to the information after the plea has been taken cannot be made over the objection of the accused, for if the original would be withdrawn, the accused could invoke double jeopardy. Substitution of complaint or information. It requires or presupposes that the new information involves a different offense which does not include or is not necessarily included in the original charge. Hence the accused cannot claim double jeopardy. Formal amendment. A formal amendment is made when 1. It neither affects nor alters the nature of the offense charged, or 2. The charge does not deprive the accused of a fair opportunity to present his defense, or 3. It does not involve a change in the basic theory of the prosecution. Substantial amendment. There is an amendment in substance where it covers matters involving the recital of facts constituting the offense charged and determinative of the jurisdiction of the court. Prejudicial question. It is an issue involved in a civil action which is similar or intimately related to the issue raised in a criminal action, the resolution of which determines whether or not the criminal action may proceed. Preliminary investigation. It is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof, and should be held for trial. Inquest proceeding. It is an informal and summary investigation conducted by a public prosecutor in criminal cases involving persons arrested and detained without the benefit of a warrant of arrest issued by the court for the purpose of determining whether or not said persons should remain under custody and correspondingly be charged in court. Arrest. It is the taking of a person into custody in order that he may be bound to answer for the commission of an offense. Warrant of arrest. It is a legal process issued by a competent authority, directing the arrest of a person or persons upon the grounds stated therein. Probable cause. It refers to facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed by the persons involved. It need not be based on clear and convincing evidence of guilt. It simply implies probability of guilt and requires more than bare suspicion but less than evidence which would justify a conviction. In flagrante delicto arrests. It is an arrest made by a peace officer or person when, in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Hot pursuit arrest. It is an arrest made by a peace officer or person when an offense has been committed and he has probable cause to believe based on personal knowledge of facts and circumstances that the person to be arrested has committed it. Personal knowledge. It means actual belief or reasonable grounds of suspicion that the person to be arrested is probably guilty of the offense based on actual facts. Personal knowledge has no reference to the actual commission of the crime but to personal knowledge of facts leading to probable cause. Bail. Bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman, to guarantee his appearance before any court as required under the conditions prescribed under the rules. Corporate surety/bail bond. It is an obligation under seal given by the accused with one or more sureties and made payable to the proper officer with the condition to be void upon performance by the accused of such acts as he may be legally required to perform. Property bond. The title of the property will be used as security for the provisional liberty of the accused which shall constitute a lien over the property. Court-martial offences. The right to bail has traditionally not been recognized and is not available in the military, as an exception to the general rule embodied in the Bill of Rights. Cash deposit or cash bond. It is deposited by the accused himself or any person acting in his behalf. Cash shall be in the amount fixed by the court or recommended by the prosecutor who investigated the case. Recognizance. It is an undertaking of a disinterested person with high credibility wherein he will execute an affidavit of recognizance to the effect that when the presence of the accused is required in court, the custodian will bring him to that court. Capital offense. A capital offense is an offense which, under the law existing at the time of its commission and of the application for admission to bail, may be punished with death. Hold departure order, A.D.O. It is an order issued by the Secretary of Justice or the proper RTC commanding the Commissioner of the Bureau of Immigration to prevent the departure for abroad of Filipinos or aliens named therein by including them in the Bureau's hold departure list. Allow departure order, A.D.O. A.D.O. is a directive that allows the traveler to leave the territorial jurisdiction of the Philippines. This is issued upon application to the Commissioner of Immigration and the appropriate government agency. Arraignment. It is the formal mode of implementing the constitutional right of the accused to be informed of the nature of the accusation against him. Plea bargaining. Plea bargaining in criminal cases is a process whereby the accused and the prosecution work a mutually satisfactory disposition of the case subject to court approval. It usually involves the defendants pleading guilty to a lesser offense or to only one or some of the counts of a multi-count indictment in return for a lighter sentence than that for the graver charge. Searching inquiry. The purpose of searching inquiry is to determine whether the plea of guilty was made voluntarily and whether the accused understood fully the consequence of his plea. Improvident plea. It is a plea without information as to all the circumstances affecting it. It is based upon a mistaken assumption or misleading information or advice. Motion to quash. The designated purpose of the motion to quash is to assail the validity of the criminal information for defects or defenses apparent on the face of the information. Double jeopardy or res judicata in prison gray. It means that when a person is charged with an offense and the case is terminated either by acquittal or conviction or in any other manner without the consent of the accused, the latter cannot again be charged with the same or identical offense. Identity rule. It states that there is identity between two offenses not only when the second offense is exactly the same as the first, but also when the second offense includes or is necessarily included in the first offense or an attempt or frustration thereof, or when it necessarily includes or is necessarily included in the offense charged in the first information. Variance doctrine. It states that an accused can be convicted of an offense only when it is both charged and proved.